Okay, this is part 3 of this chapter on book 3, chapter 4. And right now we're talking about the Court of Chancery. And you really need to go reread this stuff over and over. If you remember a couple weeks ago, Brother Rob went to a clerk of the court's office out in New Mexico, and was told by the clerk after he accepted her oath and did a few other things that he may want to go see the Archbishop for some of his answers. And now we're talking about the Court of Chancery. And in the last one we talked about them having the conscience of the king and also his great seal. What that might mean as far as their registration of your body. But let's continue on. It is therefore probable that when the courts of law, proceeding merely upon the ground of the king's original writs and confining themselves strictly to the bottom, gave a harsh and a perfect judgment, an application of redress used to be to the king in a person assisted by his privy council. So first they do it by law, and then they go get together and say, okay, now how are we going to make this right? From whence arose the jurisdiction of the court of request, which was virtually abolished by the statute of something, and they were wont to refer the matter to the chancellor and the select committee, or by degrees to the chancellor alone. So it used to be they had the court of request got involved. Well, now that's not there anymore, so now it goes to the chancellor, who mitigated the severity or supplied the defects of the judgment pronounced in the courts of law upon weighing the circumstances of the case. Okay? But now he can also determine the law, right? So if he says it's lawful, one man can say, yeah, it's lawful, here's the remedy. This was the custom not only among our Saxon ancestors before the institution of the King's Bench, or whatever this one was, and also after its dissolution in the reign of Henry I, if not that of Edward I, if not that of Henry II. In these early times, the chief judicial empowerment of the Chancellor must have been in devising new writs, directed to the courts of common law to give remedy in cases where none was before administered. Directed to the courts of common law to give remedy in cases where none before was administered. And to quicken the diligence of the clerks in the chancery who were too much attached to the ancient precedences it provided by statute whatever, whensoever and thenceforth, in one case a writ shall be found in the chancery, and in like case, falling under the same right and requiring like remedy, no precedent or writ can be produced, the clerks in chancery shall agree in forming a new one. So if it's been done before, even if they can't find one, in a like case fall under the same legal right requiring remedy, no precedent, like remedy, no precedent of writ can be produced, the clerks in chancery shall agree to forming a new one. And if they cannot agree, it shall be adjourned to the next Parliament, where a writ shall be framed by consent of the learned in law, lest it happen for the future that the court of our lords the king be deficient in doing justice to the suitors. So if they can find where if you bring in a complaint of a certain kind for a writ, and there's already one in chancery, well then they'll sue it out to you. If not, they're going to make one up. That's what they do. They write new writs. In the early times, chief judicial employment of the chancellor must have been devising new writs. Ain't got one, we'll make one. And this accounts for the great variety of writs of trespass on the case. Now there's all sorts of writs of trespass to be met with in the register, whereby the suitor had already relief according to the exigency of his business and adapted to the specialty, reason, and equity of his very case. So I think they're saying for all these things they're doing, there's already the writ for the answer back, right? We just need to go and ask intelligent questions to the chancellor and these people that work for him in the court of chancery. We need to find it. Which provision with little accuracy in the clerks of chancery and little liberty of the judges by extending rather than narrow remedial effects of the writ, might have effectually answered all the purposes of the court of inquiry, except that of obtaining a discovery by oath of the defendant. Might have effectually answered all purposes of the court of equity, except that of obtaining a discovery by oath of the defendant. So we need to get a discovery by oath of the defendant. And of course, they're the defendant when you get these writs done, as I'm understanding it. But when, about the end of the reign of King Edward III, uses of land were introduced, this is the statute of uses coming out now, from which Sextus v. use starts. And although totally discountenanced by the courts of common law, were considered as fiduciary deposits and binding in the conscience by the clergy. The separate jurisdiction of the chancery as a court of equity began to be established. So the courts of common law said that, this shit doesn't, said statute of uses doesn't apply. So this John Waldman, who was Bishop of Salisbury and Chancellor to the King, by strained interpretation of the above-mentioned statutes, he really had to twist this one, devised the writ of subpoena, returnable into the court of chancery only. If you get a writ of subpoena, it's returnable only to the court of chancery. To make the fiafi to uses accountable for his sesticque use. Alright, so they're trying to make you accountable to your sesticque use, which process was afterwards extended to all other matters wholly determinable at common law upon false and fictitious suggestions, for which therefore the Chancellor himself is by statute directed to give damages to the parties unjustly aggrieved. So, when it's determined that this subpoena isn't lawful, and it's done upon false and fictitious suggestions, because it's going against your all capital letter name is all that's one thing I'd say. That's a fictitious suggestion, that you're that. That you're that name. No, I'm the king. From which therefore the Chancellor himself is by statute directed to give damages to the parties unjustly aggrieved. That means pay you. But as the clergy, so early in the reign of King Stephen, had attempted to turn their ecclesiastic courts into courts of equity by entertaining suits for breach of faith as a spiritual offense against the conscience, going to get you confess against yourself 3 times in case of non-payment of debts or any breach of civil contracts, let those pleas of debts which are due with or without the interposition of a trust be in the king's jurisdiction. They're going to try to get you for breach of faith. Therefore, probably the ecclesiastic chancellors, who then held the royal seal, held the seal, were remiss in abridging their own newly acquired jurisdiction, especially as spiritual courts continued to grasp at the same authority as before for breach of faith, so late as the 15th century, till finally prohibited by unanimous concurrence of all the judges. Basically said, if you're going to do it, you're going to do it in the court of chancery. However, it appears from the Parliament rolls that in the reigns of Henry IV and V, the Commons were repeatedly urgent to have the writ of subpoena entirely suppressed, as being a novelty devised by the subtlety of Chancellor Waltman against the form of common law, whereby no plea could be determined unless by examination and oath of the parties. This is what the law says. No plea could be determined unless by examination and oath of the parties according to the forms of law, civil, and the law of the Holy Church in subversion of the common law. So, according to the form of law, civil. See, nobody's taken an oath in the civil law or the law of the Holy Church, I guess. So if you have ever, or are now under subpoena, enter a plea of the Crown for examination of oaths to the King's Bench. Or Actually, these go directly back to the Court of Chancery. These subpoenas do. So the Chancellor has jurisdiction over law and equity. Ask him. But we got to go to the right court, right? These people are wearing two hats. You can't do it in their civil court, right? You need it to take it to the correct court. But though Henry IV, being hardly warm in his throne, gave a palatine answer to the petitions and actually passed the statute whereby judgments at law are declared irrevocable unless by a taint or writ of error, yet his son put a negative at once upon the whole application. And the process by bill and subpoena had become the daily practice of the court. So one king put in to stop it. His son put in a negative. Now it lets him do it. But this did not extend very far. For an ancient treatise entitled the Diversity des Courtis, which, again, I haven't had a chance to look at, but it would probably be a good read, supposed to be written in the early 16th century, we have a catalog of the matters of conscience then cognizable by subpoena in Chancery, which fall within a very narrow compass. So if you have a subpoena that falls outside of what's allowed in this Diversity des Courtis, then it's unlawful. And I'm going to guarantee you that that's what they've done, right? We need them to go verify it for us. No regular judicial system at the time prevailed in the court, but the suitor, when he thought himself aggrieved, found a delusatory or uncertain remedy according to the private opinion of the Chancellor, who generally an ecclesiastic, sometimes though rarely a statesman, all right, no lawyer having sat in the Court of Chancery from the times of the Chief Justice Thorpe, this is in the 1300s, to the promotion of this other guy in 1530. So, you know, there's 180 years there where they had a statesman or an ecclesiastic sitting in as the chancellor. And so they couldn't give a certain remedy because they didn't know the law. And so during this time, so after which the Great Seal was indiscriminately committed to the custody of lawyers or courtiers or churchmen according to the convenience of the times and the disposition of the prince required, till Sergeant Puckering made Lord Keeper, so he was made the Lord Keeper of the Great Seal, from which time to the present the Court of Chancery has always been filled by a lawyer. So the Chancellor is a lawyer. Excepting the interval from 1621 to 1625, had some shenanigans to put in there, when the seal was entrusted to Dr. Williams, the Dean of Westminster, but afterwards Bishop of Lincoln, who had been chaplain to Lord Elsher when Chancellor. Okay. And in the time of this lord, 1666, arose notable dispute between the courts of law and equity, set on foot by Sir Edward Coke. Good for you. Go get him, Edward Coke. Then Chief Justice of the Court of the King's Bench, whether a court of equity could give relief after or against a judgment at common law. So if common law had already made a judgment, could the court of equity give a different judgment? This contest was so warmly carried on that indictments were preferred against the suitors, the solicitors, the counsel, and even the master in chancery for having incurred forewarning by questioning in a court of equity a judgment in the Court of the King's Bench. So they're saying a court of equity can't question the judgment of a King's Bench. By questioning in a court of equity a judgment in the Court of the King's Bench obtained by gross fraud and imposition. So they got this judgment in the King's Bench by gross fraud. This matter being brought before the king was by him referred to his learned counsel for their advice and opinion, who reported so strong in favor of the courts of equity that his majesty gave judgment on behalf, but not contented with the the reasons and precedents produced by his counsel, he chose rather to decide the question by referring it to the plenitude of his royal prerogative. So it's up to you, is what he's saying to me. I say that equity can overturn a judgment from the court of the King's Bench obtained by gross fraud and imposition. Again, they're going to charge you with trespass that didn't happen. That's fraud. Sir Edwin Coke submitted to the decision and thereby made atonement for his error. But this struggle, together with the business of commandamus, which he acted a very noble part, and is controlling the commissioners of the sewers, right? That's the court of the pipe. That's your drain commissioner. Were the open and avowed causes, first of his suspension and soon after his removal from office. So he gave himself up for the cause, right? They're making it sound like he did something bad, but he didn't. So a commendam, the tenure of a benefice to be held until the appointment of a regular incumbent, imposed as an obligatory or duty. So until the appointment of an obligation or duty, the benefice being said to be held in something. It's just a tenure of benefice. So whatever Coke did, right, he leaves this. They make it sound like he was thrown out of office. Yet he writes 4 books that become the Institutes of Law, which are considered to be books of authority. So then Lord Bacon, who succeeded Lord somebody, reduced the practice of the court into a more regular system, but did not sit long enough to effect any considerable resolution of the science itself. And a few of his decrees which have reached us of any great consequence or posterity. Many chief justices of the King's Bench have been promoted to chancellor. That's who usually is the chancellor now, in my opinion. He was a chief justice before on the King's Bench. So he may be the elder, actually, in that group that makes up the 4 sovereign coroners. I don't know. Going to find him. Going to ask for the chancellor of the Chancery Court. That's who you're looking for. His successor in the reign of Charles I little improved upon his plan, and even after the restoration of the seal was committed to the some earl, who had withdrawn from the practice as a lawyer for 20 years, and afterwards to another earl who had never practiced at all. All right, so, they keep giving this to people, this title to people who, didn't really practice. And then, but Sir Finch, who succeeded in 1673 and became afterwards Earl of Nottingham, and was a person of the greatest abilities and most uncorrupted integrity, and therefore master and zealous defender of the laws and constitutions of his county, and endued with the pervading genius that enabled him to discover and pursue the true spirit of justice, notwithstanding the embarrassments raised by the narrow and technical notions which then prevailed in the courts of law, and the imperfect ideas of redress which possessed the courts of equity. So, regardless of this man, this Sir Heneage Finch, enabled him to discover and to pursue the true spirit of justice. So he's done some things that I think are going to come to our help. The reason and necessities of mankind arising from the great change in property by extension of trade and abolition of military tenures cooperated in establishing his plan to enable him in a course of 9 years to build a system of jurisprudence and jurisdiction upon wide and rational foundations, which have been extended and improved by many great men who have since presided in chancery. And from that time to this, the power and business of the court have increased to an amazing degree. They have all the power. From this court of equity and chancery, as from other superior courts, an appeal lies to the House of Peers. But there are differences between the appeals from a court of equity and writs of error from a court of law. The former, being the court of equity, may be brought upon interlocutory matters. The later, courts of law, upon nothing but only definitive judgment. Then on writs of error, the House of Lords pronounces the judgment. So if you bring something from the court of law, they're going to pronounce a judgment. If you're appealing through the court of equity, the court below they're going to tell them to rectify their own decree. They're going to send down an order for them what to do. And an interlocutory pronounced or decided during the course of an action or suit and merely temporary or provisional in nature. So when they pronounce sentence during the course of an action or suit, it's merely temporary or provisional in nature. And in which case you do an appeal. To the House of Peers. So we got to figure out who the House of Peers is. I'm going to say that is what is the true grand jury of the county, where it's all the officers of the county. So the next court I shall mention is one that has no original jurisdiction, but is only a court of appeal to correct the errors of other jurisdictions. This is the Court of the Exchequer Chamber, which is first enacted to determine causes upon writs of error from the common law side of the Court of Exchequer. So if you put a writ of error into the Court of Exchequer from the common law side, then it went to the Court of Exchequer Chamber. And to this end, it consists of the Lord Treasurer, Lord Chancellor, Justice of the King's Bench, and Common Pleas. They're the ones who make up the Court of the Exchequer Chamber. Its imitation of which a second Court of Exchequer Chamber was erected, consisting of Justices of Common Pleas and Barons of the Exchequer. So here's the mirror. All right? For the law side, you want this side here. The Lord Treasurer, Lord Chancellor, Justice of the King's Bench. This other one here, Justice of the Common Pleas and Barons of the Exchequer, I think are for the fiction side. Before whom writs of error may be brought to reverse judgments in certain suits originally begun in the Court of the King's Bench. So they brought trespass charge against you. Go show them your title. They're saying they have a superior claim to your land than you do. Well, you're the copyhold. You gave them the lease. You are the you have the superior title. Into the court also the Exchequer Chamber, which then consists of all judges of the three superior courts, and now and then the Lord Chancellor, are sometimes adjourned from the other courts, such cases as judges upon argument find to be great weight and difficulty before any judgment is given upon them in the court below. Consists of the Lord Treasurer, Lord Chancellor, Lord Justice, the King's Bench, and Common Pleas. I put that down there for a reason. Oh, the Court of Exchequer Chamber, which consists of all judges of the three superior courts. And now, so this is the one for the common law side. From all the branches of this Court of Exchequer Chamber, a writ of error lies to. From all branches of this Court of Exchequer Chamber, a writ of error lies to the House of Peers, which is the supreme court of judicature in the kingdom, having at present no original jurisdiction over causes, but only upon appeals and writs of error. So you either appeal or send in a writ of error to rectify any injustice or mistake of law committed in the courts below. This is the House of Peers. So who's on the House of Peers? Well, I guess we're going to find out. To this authority they succeeded, of course, upon dissolution of the King's Bench, or the whatever it was at the time, for as barons of Parliament were constituent members of the court, and the rest of its jurisdiction was dealt to other tribunals, over which the great officers who accompanied those barons were respectively delegated to preside. It followed that the right to receive appeals and superintending all other jurisdictions still remained that noble assembly that whichever other great court was derived. Still remained in that noble assembly from which every other great court was derived. So all the courts were derived out of the House of Peers. They are therefore, in all causes, the last resort. from whose judgment no farther appeal is permitted, but every subordinate tribunal must conform to their determinations. The law reposing entire confidence in the honor and conscience of the noble persons who compose this important assembly, that they will make themselves masters of those questions upon which they undertake to decide, since upon their decision all property must finally depend. Hereto may also be referred the tribunal established under another statute, one prelate, 2 earls, and 2 barons, who are chosen at every new parliament to hear complaints of grievances and delays of justice in the king's bench, in the king's courts, and to give directions for remedying these inconveniences in the courts below. Okay, so if you got something going on in a civil matter that doesn't seem to ever get done, you're supposed to go to directions remedying these inconveniences in the courts below to this tribunal, who's 1 prelate, 2 earls, and 2 barons. This committee seems to have been established lest they should be a defect of the justice for want of Supreme Court of Appeal during the intermission or recess of Parliament. So I don't know if that means Parliament's recessed right now. Intermission, it hasn't come back. That's what they say happened to Congress. I think it happened on all levels, and now they have this group that sits in during the recess, formed of 1 prelate, 2 earls, and 2 barons. For the statute further directs that if difficulty be so great that it may not well be determined without assent of Parliament, it shall be brought by the said prelate, bishop, earls, and barons upon the next Parliament, who shall finally determine the same. Before I conclude this chapter, I must mention the 11th species of courts of general jurisdiction and use, which are derived out and act as collateral auxiliaries to the foregoing. I mean the courts of Aziz and Nisi Prius, unless before. These are composed of 2 or more commissioners, who are twice in every year sent by the King's Special Commission all around the kingdom, except London and Middlesex, where the court Nisi Prius is held, in and after every term, before the chief or other judges of the several superior courts, to try by jury of respective counties the truth of such matters of fact which are then under dispute in the courts of Westminster Hall. These judges of Aziz came into use in the room of ancient justices of error. These judges of Aziz came into use in the room of ancient justices of basically the circuit judge, who were appointed by the great council of the realm. So I don't know if they're saying they're using the same courtroom as the circuit judge does, with the delegated power from the king's great court being looked upon as members thereof, and they made their circuit around the kingdom once in 7 years for the purposes of trying causes. You had to show up once every 7 years before a magistrate. That's what the Sesta KV says. And that's who these judges of Aziz are. So maybe this is who you need to appear before. And if they're not in session, then there's a bishop, earls, barons that make up the commission. These are composed of 2 or more commissioners, right? Well, who were the commissioners? Who were the commissioners? Oh, referred to a tribunal established by this statute to hear complaints and grievances, delays of directions for remedying the inconvenience of the courts below. This committee, committee is made up of commissioners. Okay, so that's who it is. So that's who they are. They were afterwards directed by Magna Carta to be sent to every county once a year to take or try certain actions then called recognition or Aziz, most difficult which were directed to adjourn the Court of Common Pleas to be determined. The present justices of Aziz are derived from the statute, explained in other acts, particularly in the Statute 14, and must be 2 of the king's justices of one bench or the other, or the chief baron of the exchequer, or the king's sergeants sworn. The present justices, so that's who makes up the present justices of this court, of Aziz or Nisi Prius. Two of the king's justices of one bench or the other, or the chief baron of the exchequer, or king's sergeants sworn. Well, a king's sergeant sworn to me is an appellate level attorney. Yeah, I'd think about that some more. They usually make their circuits in respective occasions after Hilary and Trinity terms, Assize being allowed to be taken in the holy time of Lent by consent of the bishops, yada yada yada, and is also usual during the times of popery for the prelates to grant annual license to the justice of Aziz to administer oaths in the holy times, for oaths being a sacred nature and logic of those deluded ages concluded that they must be of ecclesiastic cognizance. I don't know if they're talking about tax court or what they're, where they're going to come around once a year, and the time of year sounds like it's in April, and that's what I'm guessing, that it's in April sometime, around tax time. The prudent jealousy of our ancestors ordained that no man of law should be judge of assize in his own county, and similar prohibitions is found in the civil law, which carried this principle so far that it is equivalent for the crime of sacrilege for a man to be governor of a province in which he was born, or has any civil connections. So the court of Aziz were periodic criminal courts. Okay? And I think that here what we're talking about, maybe this has to do with why the Secretary of State, Secretary of Treasury, Attorney General all have to expatriate. I don't know. Who knows? But this is why they send in people from outside, basically. The judges upon their circuit sit by virtue of five several authorities: the Commission of the Peace, the Commissioner of to hear and determine, the Commission of General Jail Delivery, the consideration of all which belongs properly to the subsequent book and these commentaries. Okay, so those all have to do with criminal. But the fourth is the Commission of Aziz directed to judges and clerks of Aziz to take Azizes, that is, to take the verdict of peculiar species of jury called an assize and summoned for the trial of landed disputes of which hereafter. And I think those are grand aziz of 12 nights is one kind of aziz. Are summoned for trial on landed disputes. Well, we're going to have a landed dispute. Who the frick owns my land, right? It's my earth and vessel. I'm the immortal living spirit, created in the image of God. I'm a son of God. It's my land. The other authority is 5. Nisi Prius, which in consequence of the Commission of Aziz being annexed to the office of these justices by statute, and employs them to try all questions of fact issuing out of the courts of Westminster that are then ripe for trial by jury. So, to try all questions of fact, right? So, again, I think that this is what they call a grand jury. The original of the name of this, all causes commenced in the courts of Westminster Hall, are by the course of courts appointed to be tried on a day fixed in some Easter, by jury returned from the county wherein the cause of the action arises. But with this proviso, unless before the day prefixed the judges of assize come into the county in question. They are sure to do in the vacations preceding each Easter, Macamelius terms, and there dispose of the cause, which saves much expense and trouble, both to the parties and juries and witnesses. So they're going to come there to dispose of it instead of you going someplace else, to Westminster Hall. These are several courts of common and equity, which a public and general jurisdiction throughout the kingdom, and upon the whole we cannot but admire the wise economy and admirable provisions of our ancestors in settling this distribution of justices in a method so well calculated for cheapness, expedition, and ease. Let's find out if that's true. By the Constitution, which they established, all trivial debts and injuries of small consequences were recovered and redressed in every man's own county, hundreds or perhaps parish. That's the county court of the sheriff. Pleas of freehold and more important disputes of property were adjourned to the King's Court of Common Pleas. That's the one we go to. The civil court. Subject on subject, which was fixed in one place for the benefit of the whole kingdom. Crimes and misdemeanors were examined in a court by themselves, and matters of revenue in another distinct jurisdiction. So crimes and misdemeanors by the King's Bench, matters of revenue in another one, the Exchequer. Now, indeed, for the ease of the subject and greater dispatch of causes, methods have been found to open all three superior courts of redress for the redress of private wrongs, which have remedied many inconveniences and yet preserved the forms and boundaries handed down to us from high antiquity. So again, I say they have three courts going at one time in every case. You got one in common law under the King's Bench. That was the writ for trespass. You have the statute merchant. They're trying to get you to acknowledge. That's happening in equity. And then they're charging you for some trivial matter in the courtroom, so they can get you to acknowledge the writ, get you to acknowledge the statute merchant in the back, the bond, the indictment, that type of thing. But it started with a fraudulent trespass, because the guy who brought it said that he had jurisdiction over your estate, and all we need to do is challenge that. If the facts are disputed, they are sent down to be tried in the county by their neighbors. But the law arising upon those facts is determined by the judges above. And if they are mistaken in points of law, there remains in both cases two successive courts of appeal to rectify such of their mistakes. And the rigor of general rules does in any case bear hard upon individuals. Courts of equity are open to supply the defects but not sap the fundamentals of the law. Lastly, there presides over all one great court of appeal, which is the last resort in matters both law and equity, and which therefore takes care to preserve in uniformity and equilibrium among the inferior jurisdictions. A court composed of prelates selected for their piety and nobles advanced to their honor for their personal merit, or deriving both honor and merit from the illustrious train of ancestors, who are formed by their education, interested by their property, and bound upon their conscience and honor to be skilled in laws of their country. This is a faithful sketch of the English jurisdiction, designed by masters' hands of our forefathers, for which great original lines are still strong and visible, and if at any minute stroke are by length of time all obscured or decayed, they may still be with ease restored to their pristine vigor, and that not so much but faithful alterations and wild experiments, so frequent in so fertile age, as by closely adhering to the wisdom of the ancient plan concerted by Alfred and perfected by Edward, and by attending to the spirit without neglecting the forms, of which they're excellent and without neglecting the forms of their excellent and venerable institutions. Okay, that's a lot of stuff, people, and I know it's about 3 hours, and I've read it 4 times. I'm starting to understand it. I don't know all of what this is, but I know they're pointing out all the things we can do. Please watch it 2 or 3 times, or go read it yourself and start making your own notes, and let's figure out what these things are and where they're at. He's saying what they're called. If you were to cut and paste Blackstone's Commentaries English Law, Book 3, Chapter 4, highlight the parts that you think pertain to you, and take that in when you talk to these people and tell them, I'm reading this out of Blackstone's Commentaries English Law, Book 3, Chapter 4. This is a book of authority used in court is the law, so this is the law. So what is this? and find out where these people are, and let's start taking them to task. And drive that frickin' wooden stake into the heart of the vampire, the bloodsuckers. Love you all, man. Take care.